I just watched the full 3-hour and 14-minute deposition of Alex Jones. This is my analysis as a lawyer. For those of you who don't know me, I am Viva Frei, a Montreal litigator turned YouTuber. I make law vlogs, among other types of videos on my channel where we discuss and analyze things in the news from a legal perspective. Last week someone had asked me what I thought of the attorney's conduct in the deposition of Alex Jones. For those of you who don't know, Alex Jones is being sued by 6 parents from the Sandy Hook shooting for defamation. In the months and years following that shooting, Alex Jones promoted a number of absolutely unsupportable conspiracy theories. First and foremost was that the parents were actually crisis actors. 6 of the parents are suing Alex Jones for defamation, alleging that as a result of the conspiracy theories that Alex Jones promoted, in addition to causing them anguish and pain that you can't possibly imagine, other people started harassing them, believing Alex Jones's conspiracy theories that they were actually crisis actors. Now, I am only certified to practice law in Quebec, and the Quebec law on defamation is a little different than the US law on defamation. I did a video on this previously, which I'll post the link to now. In the United States, in order to succeed on a claim of defamation, you have to prove that the statements that were made were false, that they were done maliciously with the intent to harm or out of negligence, and that harm was in fact suffered. In Quebec, we have a bit of a nuance in that the statements don't actually have to be false in order to constitute defamation. The statements can be in fact true, but if they are uttered for the purposes of causing harm, it can still constitute defamation under our civil liability system. And in virtue of the freedom of the press generally benefits from a higher threshold of what they are allowed to publish, and the threshold is a little bit higher when it relates to celebrities who live in the public eye and are therefore subject to more scrutiny. Regardless, I'm not going to get into the nuances of defamation law. Right now I'm going to analyze the deposition and the conduct of the attorneys and how this examination went.
We are on the record for the videotape deposition of Alex Jones, taken on Thursday, March 14th, 2019. The time is approximately 12:02 p.m.
So the first thing is, it's very interesting. Alex Jones looks visibly nervous, drinking water, making a confused face when they're mentioning the date. These are all gestures that would manifest in anybody being examined. Being examined is not a comfortable experience, right or wrong, good or bad. Nobody likes being cross-examined by lawyers. Let's keep going.
But get a hold of your cousin when she settles down and get her to talk to us for any other information. We need to know, were there any drills that day or the day before? They are going to come after our guns, look for mass shootings. And then magically it happens. They are coming, they are coming, they are coming.
Mr. Jones, this is a video where you made comments on issues relating to Sandy Hook, and you put forward a theory that it could be staged by the government to take away our guns, correct?
One objection. It seems like this is a video from watching it. There's different pieces put together.
Correct.
Okay, so it's not from, so different things are out of context. Is there any way to get like the whole?
You own the whole video, and it's been produced with Mr. Zepsafadu.
Okay, but for his purposes, so he's just getting.
If he wants to go watch an entire 4-hour video, I'm not going to have time for that
Marking has
now.
not been produced with Zips video.
Actually, Connecticut full video has been produced, and it's been in the court. If you want to argue about that and object, you can object at that at the time it's offered. That objection's preserved. You don't have to object to form to that.
This is a mistake that the plaintiff's attorney made in the early stages of this examination, which are going to come back and cause him problems throughout the examination. The lawyer put together himself a compilation of Alex Jones clips where he said certain things in InfoWars and on YouTube. The problem is that the lawyer did not use the native clips to introduce them to Alex Jones. He made a montage himself. That is to say, the attorney edited together a montage which he then presented to Alex Jones. The problem with this is that attorneys are not supposed to admit evidence. They're not supposed to produce evidence themselves. They produce exhibits which have to be admitted as evidence later on. In order to admit something as evidence, you need the person who took the picture, who made the recording. And so the attorney, instead of using the unedited clips to present them to Alex Jones to get Alex Jones to admit his own videos into evidence, the lawyer spliced together short clips and then presented it to Alex Jones so that Alex Jones now says, I have no idea where these are taken from, what date they were taken on, and why they're spliced together or edited in the way they are edited together. It's a strategic mistake that allows the witness to get out of answering any questions on it because it is effectively edited, doctored material, edited by the attorney asking the questions on it. And I understand what the attorney was trying to do. He edited together for impact, to show in sequence the number of things that Alex Jones said over the years. The problem is, in that editing the video together, the lawyer becomes the creator of the evidence, so to speak, and not the presenter of the evidence. And this allows Alex Jones and his attorney to object to any line of questioning really on this, because the context has been edited, the video has been edited by the attorney asking the questions on it.
The truth is, Mr. Jones, you were the first person in the world to make the false flag theory about Sandy Hook and you did it before the bodies were even cold. That's the truth.
No, it's not true.
This type of question illustrates how not to ask a question in examination. You were the first person in the world to put together that theory. It makes it such an easy question to deny the truthfulness of. How is one going to prove that Alex Jones was the first person in the world to produce that conspiracy theory? It's unprovable, and it allows the witness to simply deny it. No.
No, it's not true. No, it's not true. No, it's not true.
Instead of saying, this is the theory that you put forward in the wake of, the question is phrased in a way that allows the witness to easily deny it, and it's phrased in a way that becomes impossible to prove. How do you prove that Alex Jones was the first person in the world to put forward that conspiracy theory?
Mr. Jones, you said in your affidavit that before you commented on any issues relating to Sandy Hook, you saw other things that other people were doing. That affidavit has false statements, doesn't it?
No.
That affidavit has false statements, doesn't it? What does he expect the witness, who is a hostile witness, to answer to that question? Yes, that affidavit includes false statements. We're going to see this throughout the examination, but this lawyer is distracted by arguing with and trying to plead with the witness, as opposed to get the witness to produce information that the lawyer can then use later on in the file. That type of question is never a question that you're going to get a yes out of the witness. Yeah, I made a false statement in my affidavit. Asking it is a form of argumentation and not a form of interrogation.
Mr. Jones, I have a very simple question for you. That video you just saw of you talking, were you talking about Sandy Hook?
The edited pieces were.
The pieces that I edited and put together of you speaking.
Believe me,
yeah,
it matters.
I edited them. When I edited those pieces together and put them in front of you, was that you on the camera?
You're saying you edited that?
Yeah, I did, Mr. Jones. It's not a.
But you did edit it.
It's not an important deal. I did. Yes, I'm not here to answer questions.
3-second clips together.
Those clips were edited together by me 2 weeks ago.
Oh,
from your
okay.
video.
Why didn't you just play it unedited?
That's, Mr. Jones, I'm not here to answer your questions. There is no dispute that the Sandy Hook tragedy was real, with tragic loss of life. You stand by that?
I'm sorry, you're talking so fast.
Sure. Let me slow down a little bit for you, Mr. Jones.
Let me slow down a little bit for you, Mr. Jones. First of all, this is the type of behavior that judges don't necessarily appreciate, which is this condescending, rude, demeaning behavior towards the witness, as much as the lawyer may have utter disdain for the witness. The first thing is, the lawyer is talking too fast. He's asking a question, and it is too fast for a witness who's going to be sitting there for 4 hours answering questions. The questions have to be slowly presented, they have to be concise, and they can't be convoluted. And we're going to see throughout this examination, sometimes the questions are extremely convoluted. It makes it difficult, if not impossible, for the witness to answer, or it allows the witness to say, I don't understand that question, and it sort of frustrates the flow of the examination. Short, clear, concise questions that are difficult to misunderstand and easy to answer.
Recently, your lawyer said, in a legal document, there is no dispute that the Sandy Hook tragedy was real, with tragic loss of life. You stand by that. That's what you admit is true now.
Yes.
Mr. Jones, hold on 1 second. I'm going to play you a clip from December 29th, 2014. You go ahead and play that for me.
But it took me about a year with Sandy Hook to come to grips with the fact that the whole thing was fake. I mean, even I couldn't believe it. I knew they jumped on it, used the crisis, hyped it up, but then I did deep research, and my gosh, it just pretty much didn't happen.
That's you saying you did deep research, correct?
The same objections to form, and that these are highly edited excerpts.
So the audio's been altered on all these.
Yeah, can you stop with speaking objections?
Well, I'm just
I know exactly what you're doing, and you need to say objection form, objection leading, assertive privilege, or stay quiet. You do not need to be making suggestive objections about the content of the evidence and what its form is. You don't need to be doing that, Mr. Barnes.
I'm not trying to do that. I'm just saying that these are videos that are highly,
Mr. Barnes, I haven't seen
that's
a
these-
great
these
opinion.
are done before.
I don't understand why your opinion is irrelevant to this questioning right now. You wouldn't be doing this in a courtroom. Don't do it in my
Oh, yeah,
deposition.
in a courtroom, it wouldn't come in because it wouldn't be admissible. Because
Then that is why you're
the rule of completeness.
And this is interesting because the examining attorney says to the other lawyer, don't object, you wouldn't be doing this in front of a judge, so don't do it during the examination, which is not done in front of a judge. To which the other lawyer responds, this wouldn't be happening in front of a judge because we would not be dealing with evidence that you as an attorney produced and then presented to the witness for examination. You wouldn't do this in front of a judge.
Mr. Barnes, that's why your objection is preserved as to the form of that evidence. You don't have to raise an objection. The only reason you would be doing it is to possibly influence the witness. And so let's stop
Can
talking.
you have a standing stipulation that when I object to form, that includes an objection to the rule of completeness?
Absolutely.
Thank you.
Although,
Then we're good. We're good.
and we'll also put on the record, every objection to every piece of evidence is preserved under the Texas rules. which is part of Rule 199.
This back and forth between the attorneys and the examining attorney's response is an indication that the examination is not going the way he planned. I think he's recognizing he made a mistake now in himself personally editing together these videos, and now he's trying to call it bully or intimidate the objecting attorney into staying quiet over the objections raised to the production of this edited video. I'm a Quebec lawyer, I don't know the Texas rules of practice. What I suspect is going on here is that the lawyer is saying, object, state the basis of the objection, but don't go into illustrating or elucidating in any greater detail why you're objecting to the production of the document. And what the examining attorney is doing is a common tactic when a lawyer interrupts, is you accuse that lawyer through the objection of trying to lead the witness. The problem is, when you put together a highly edited video and then present it to the witness and you're the one who actually edited it, you then, in a sense, become a witness to the production of evidence, which is not the role of the examining attorney, and it leads to this type of confusion, argumentation, and distraction during the examination.
I'm not trying to
Excuse me, counsel. You were speaking over one another. You're making the record very messy.
This is very interesting. Now, in Quebec, we do not video record examinations. It's not the first time I've seen a video recording of examinations, because that's what they do in the States. In Quebec, we just have an audio recording of the examination, which a stenographer then transcribes into a book. In this deposition, in addition to having the video, it seems that there is a stenographer there as well who is now telling the attorneys, don't talk over each other, because when I go to transcribe this, it's going to be very difficult for me to know who said what and write it down in a sort of playwright dialogue in the stenographer's notes, which is what they then produce to a judge as well.
And the kids are going in circles in and out of the building with their hands up. But then what do you do when they've got the kids going in circles in and out of the building with their hands up? I've watched the footage. And early on that day, we watched footage of kids going in circles in and out of the building. You'd be running them away from the building.
Leave it up. Leave it.
Are you saying that's part of his broadcast?
Yes, it says InfoWars right there on the bottom.
Okay, so that's part of the same broadcast.
Yes, do you see where it says InfoWars?
Just as long as you're representing that the video that you're showing him now with the people walking across was part of the same broadcast.
First of
which
all,
made statements.
there's only going to be one lawyer defending this deposition, Mr. Enoch. And you've already chosen it. No, Mr. Enoch, there will be one lawyer speaking on the record. There is one lawyer defending the deposition. I am not being tag teamed by the two of you. And so I would appreciate it if you kept your mouth shut for this deposition. Let Mr. Barnes defend the deposition.
This is interesting. So there seem to be more than one attorney on the defendant's side, presumably because there are more than one defendant. I think there's Alex Jones, InfoWars, and another entity, potentially. For the purposes of an examination, typically there is one attorney who is defending the examination and one conducting it. So you don't have what plaintiff's attorney referred to as tag team objections during an examination, because you don't want three lawyers all intervening and objecting for the person being examined. It gets confusing and it gets a little bit burdensome for the interrogating attorney. The problem is that when there's multiple parties, any attorney with an interest in the file can object to what's going on during the examination. The other thing is, practically speaking, telling a lawyer to be quiet and sit down, it's not going to work.
Mark,
Correct.
please answer my question. And it's a simple question, I'll stay for it. If you represent that the video of the school that you're showing, the firehouse, was part of the same broadcast in which he made his statements.
Yes.
That's all
Mr.
I'm
Enoch, we just watched it. Do you really think I edited his words over a different video?
What I think doesn't matter. Thank you for answering the question.
Mr. Enoch, I would appreciate it if you kept quiet the remainder of this deposition and let Mr. Barnes defend the deposition.
Looks like two different shows together. What, can you play it again?
These are three different clips, and I'll remind you, Mr. Jones, these are from November 18, 2016, April 22nd, 2017, and June 13, 2017.
You just told him it was the same broadcast.
And this one right here is the same broadcast, Mr. Jones.
Which is this the 11th?
This is November 18th, 2016.
The kids are going in circles in and out of the building with their hands up. But then what do you do when they've got the kids going in circles in and out of the building with their hands up? I've watched the footage. And early on that day, we watched footage of kids going in circles in and out of the building.
And then we saw a second clip from your Megyn Kelly interview, right?
Which again was highly edited.
Sure, totally, and I edited a piece of it into here, correct? That was from the Megyn Kelly
Wait,
interview.
time out. We need to take a break. You just told me that everything you showed him was from one video.
No, Mr. Enoch, I told you
One
what
broadcast.
was on the screen and the audio were from the same video.
If you want to take a fair deposition, you're entitled to do that. You are not entitled to misrepresent to the witness three
I'm
different dates in
walking-
deposition and say three different dates of video and say this was the same video. Were these all the clips that you showed in the same video? Yes or no?
No, and we've
Thank
said
you.
We've said that repeatedly from the moment I've asked him. They were from 3 different dates. I read the 3 different dates to you, Mr. Enoch, so your indignation can calm down. And you need to be quiet in this deposition. Mr. Barnes, can you please instruct your counsel to be quiet?
You see, the unnecessary confusion that's happening now is this lawyer has spliced together 3 different video excerpts of 3 different dates into one video and then asks the witness questions on one specific segment of that edited video. Why not just produce each video as a standalone piece of evidence for easy reference, for easy placing in context afterwards, and ask the question on those specific videos as submitted one by one? When you want to put together the argument and show the repeated conduct to prove the malice or the negligence of the defendant, you do that in argumentation before a judge. You make the montage then. The examining lawyer should not be making a montage of edited pieces of evidence for the purposes of the examination. It leads to problems like this.
That school that you just saw on screen is not rotting, is not falling apart, and does not look to be abandoned, does it?
It looks dilapidated.
Okay, Mr. Jones.
And this is another example of how not to ask a question in examination. He asked Alex Jones a question of opinion. Alex Jones is here as a witness of fact, not as a witness of opinion. He's supposed to testify on what happened when, what he did, what happened. The lawyer is now asking him a question of opinion in terms of assessing the state of a building. And then when he doesn't get the answer he wants, he scoffs at the answer. That is sort of how you defensively and argumentatively deal with an answer that you don't like. But that's what you get when you ask a question that allows a witness to say what the witness wants. When you ask a witness a question of opinion, the witness can say what they want. When you ask a witness a question of fact, they have to answer factually as to what happened.
Well, I may need to take a, I think during the break I'm going to go to the bathroom and stuff.
Sure, you can go to the bathroom. I'm not going to stop you from that, Mr. Jones. I'm not. Your bodily functions are your own. Let's go ahead and go off the record. You don't have to do speaking objections, Mr. Barnes.
It's one of the worst depositions I've ever witnessed.
That's fine. You can make your objections.
Fair enough.
Go make all the objections you want, but make them in accordance with the Texas rules, which you agreed to be bound with before you started this deposition.
Okay, fine.
If those videos were released in 2013, it certainly would have been reckless to say the porta potties arrived in an hour in 2017, wouldn't it, Mr. Jones?
Objection is to form.
Listen to that question. I have an expression that if you can't repeat the question 3 times in a row within 5 seconds, the question is too complicated. First of all, assuming the Texas rules are the same as the Quebec rules, you can't ask a witness hypothetical questions. You don't. They're not there to hypothesize. They're not there to give their opinions. They're not there to say what might have happened, had something happened, if something had happened, when. They're there to testify on fact.
It's a basic objection. It's learn 101 on how to ask questions. I mean, come on.
Okay.
It would be easier for you and for everybody if it was, here's the exact
Got a rule of evidence for me, maybe?
This is irritating for judges to watch down the line. This is not a competition as to whether or not you can show who's smarter than who. Give me a rule of evidence, 409, 399, 199, and people hate seeing the bickering between attorneys in an examination. They are there to examine the witness, not fight among each other to show off to the other how smart one or the other is.
Oh, sure. It gives specificity as to both date and time so the person can answer the question meaningfully. When you say...
So is that 403?
That could be well over.
That's not form. That's not. You don't have to object to that. It's preserved, Mr. Barnes.
Oh, incidentally, another rule of practice is when another lawyer tells you what to do, they're not telling you what to do in your best interest, so you do have to act accordingly.
So if InfoWars, if it happened that InfoWars went and searched and dug through records for private business filings and used DMCA reports that it had gotten to suss out that Mr. Posner was the head of honor and then reported it to its audience, that wouldn't be a good thing if that happened, right?
Objection is to form.
Well, I don't have any knowledge of what you're talking about there.
I'm just saying, if it happened, hypothetically, if hypothetically InfoWars went to some links to unmask a person who was running a charity that was trying to stop people from being abused and then disclose that to its audience with maps, that wouldn't be a good thing.
Listen to this question. If it had happened that InfoWars went and got DMCA reports, brought those out, outed somebody and doxed somebody and went after them, surely the question is so complicated, hypothetical, convoluted, it becomes impossible to answer and irrelevant even if an answer is provided because it's absolutely hypothetical. It's argumentation. We understand what he's trying to prove here, but this is the argumentation you make in closing arguments once the evidence is adduced. You adduce the evidence that InfoWars went and pulled up information. You adduce the fact that they made it public. You adduce the fact that it led to certain damages. You then, in argumentation, say that it was negligent to have done it.
That's, from my memory, not what happens. I can't comment on hypotheticals.
Sure. Oh, so if I was to say to you, if somebody was to come along and strike your hand with a hammer, would it hurt? You can't answer that question.
Objection is to.
I'm not striking anybody with hammers.
If I asked you if I gave you a big bowl of chili, might it affect your memory? You can't answer that. That's hypothetical. Correct? You're just not going to answer those kind of questions. I'll take it. That's no. Let's move on.
I'll take it. That wasn't
I mean,
a question.
yeah, that's...
Is that a question?
Is it?
That's a comment. That's not a question. This is becoming one of the most harassing objects. This is for TV and for PR, not for a legitimate suit. That's what this is. That's all this is. You want to put it on TV. That's all. This is just a show, and it's a bad show at that. It's a show of how not to be a lawyer in deposition of a case show. I mean, if you want to be fair and you want to ask real questions, go ahead. But don't make comments and then try to reinterpret those comments as a question and then try to put words in the mouth of the witness. I mean, first-year law student should know that. The objection was to your comment saying that there was an answer, and my point was you didn't ask a question, so there couldn't have been an answer, and I was objecting for the record purposes that no answer had been given to a question that had not been asked.
Do you maybe want to take a break so we can have a few breaths?
Yes, maybe so.
Yeah, you might need to do that.
I think the examining attorney is probably going to watch this and recognize where mistakes were made in the conduct of this examination, but what purpose is it to say something like that to an attorney? Does he think it makes him look good? Does he think it makes the other attorney look bad? Yeah, you might need that. It's the gratuitous bickering among attorneys. Judges hate it. It doesn't make the person look good for saying it. It doesn't make them look accommodating. It doesn't make them look smart, and it doesn't make them look like the examination is going any better than it otherwise is.
Yeah, absolutely. And maybe you can go back and read how to ask people questions.
That was not the extreme caution that your chief reporter, Mr. Watson, had been urging. Correct?
Objection, Mr. Ford.
This big boogeyman that's on Homeland, and that's not who I am.
Remember what my question was? What was my question?
I just answered your question. Answer your question again. There's no yes or no answer to something like that.
Well, you don't even know what the question was because you were just talking. You're just ranting like you do on your show, right?
No, I was being honest with you about the situation.
Now I have to preface this. My personal prediction is that Alex Jones is going to be ordered to pay damages to the parents. You don't get away with making those types of statements over an extended period of time and think that your ultimate defense is going to be freedom of speech. I'm a total proponent of freedom of speech. And like I say, I will take imperfect freedom of speech over perfect censorship any day of the week. But freedom of speech is a double-edged sword. You get to say things, but then you also suffer the consequences if you cross the line. And I think promoting the idea that the parents were crisis actors crosses the thin line between freedom of speech and defamation. But the lawyer is just arguing with the witness as though he thinks that there's a judge or jury watching that's going to render a judgment based on his pleading and not the evidence being adduced from the examination.
Situation.
In 2013, you made videos calling it fake, correct?
Objection, Mr. Ford.
I think asking if it was fake, yes, sir.
You weren't asking, you were saying it was fake, and the evidence is overwhelming, right?
We have a right in this country to question things.
I'm not saying what you didn't have a right to do. I'm just asking you what you did. Mr. Jones, can you now admit that these statements were reckless?
How does he think Alex Jones is going to answer that question? The lawyer seems to be thinking he's going to have his a few good men moment where he's just going to break Alex Jones down. He's going to say, yes, I admit it, I was wrong, it was all terrible, it was all a mistake, punish me. Alex Jones, for all his foibles, is not dumb. He's a prepared witness. How does the lawyer think he's going to answer that question? Does he think he's going to answer it with a case-crushing admission, or does he think he's going to deny it and then offer an explanation? I know what Alex Jones is going to answer before he answers it.
No, I think at that point in my life, and wherever the context was, that I was saying, I think basically the whole thing is fake. That's my right to do that. I legitimately have believed that Sandy Hook was probably completely staged. Different periods of my life, like I believe Jesse Smollett was staged, or the WMDs were staged. And I'm on record on hundreds of these events when I think they're staged. I've learned sometimes I'm wrong. So no, I stand by the fact that I genuinely believe that. And one of my best reporters, Paul, thought that was wrong. And so that shows that we have real debates, real discussions. And what people believe, as long as I think they really believe it, is what we debate and discuss.
Can you now admit that you've done an outrageous wrong to these parents? Can you admit that?
The mainstream media is who always takes it, makes it a huge issue, and then says that I'm saying it and gets me to respond. And it's lawyers like you and people that glom onto this for fame that then try to get the fame and then say that I'm the person that's promoting it. And it's obscene, in my view.
So that's no.
No, I genuinely questioned, and I think the government and media that's been caught lying so much has created an atmosphere where people don't know what's true.
So you do not believe that you've done an outrageous wrong to these parents?
I have not. No, I've not done an outrageous wrong to the parents.
Okay.
I'm not going to repeat what I said earlier, but it's the same question, it's the same mistake, and how does he think Alex Jones is going to answer that question? This is not Hollywood. You do not get your A Few Good Men moment in actual real court.
Yeah, whether Mr. Heslin was defamed is relevant to my case. You know that. The document requests are all about Mr. Heslin. Don't even start this with me. I would rather you not, because you're not defending this deposition, Mr. Enoch. I've had an extraordinary amount of patience with you speaking during this deposition, but we're not going to do this to you when we defend depositions.
Misrepresent to this lawyer that the judge did not restrict the scope to the limited to the RFPs. Do you agree that he limited to that?
No, I don't think so.
Okay.
Not to an RFP. No, I don't think so.
You don't
I don't
think
think
he
the
said
scope
anything
of...
about the scope?
No, Mr. Enoch, I don't think the scope of written discovery on request for production was identical to the scope of deposition. And many, many times, Mr. Enoch, the judge said, no, you can't ask that question for a request for production, but you can just ask it in deposition. So no, I don't agree with you at all, and I would appreciate it if you kept quiet the remainder of the deposition. You are not defending this deposition.
Mr. Bankston, I will speak if it's appropriate for you to speak.
It is not appropriate for you to speak, Mr.
That's not correct.
Sir, I'm going to ask you to leave my deposition. Go off the record for a second. I want you to leave.
not agree to go off the record.
All right, don't go off the record. Mr. Enoch, I'm asking you to leave my deposition. You are being obstructive. You are talking. You are not appearing at this deposition. You are not defending it. If you do not agree to be quiet, I'm asking you to leave the deposition.
Does the lawyer think that these threats, telling a lawyer to be quiet, is going to do anything? Conduct the examination, ignore the objections coming from the defendant, and at some point rephrase your questions, get back to getting factual information out of the witness, stop arguing with the other attorney, and make use of the 4 hours that you were allotted to examine Mr. Jones.
Are you going to stay and be quiet, or am I going to have to ask you to leave?
Bankston, I am not leaving the deposition.
Then you're going to stay quiet.
Would you like to continue your deposition?
I am, and if you leave again, if you keep speaking, I guarantee you I will seek sanctions against you, Mr. Enoch.
That's a touchy statement. I guarantee I will seek sanctions against you. That seems like a threat of an ethical complaint or a threat against the attorney personally for simply doing their job. It's not what I would do.
Would you put information on the air from a source if nobody at InfoWars knew their identity? Here's my question, Mr. Jones. How in the world would you know how much you've covered Sandy Hook, 1/10 of 10%, when we, the plaintiffs, have asked you to produce us every video that has Sandy Hook in the title, and you can't even do that?
Listen to that question. How would you know something if we had asked you to do something and you didn't do it? How about you just ask the question, how do you know if it was 1/10 of 1% of your reporting? How do you know that it was 1/10 of 1% of your recording? Easy question. Why the entire convoluted second part of it? Because it is argumentation trying to make evidence of obstruction by the party. The lawyer is not just asking, how do you know it's 1/10 of 1%? The lawyer is saying, how do you know it was 1/10 of 1% and you've been obstructing the production of evidence to us in the context of the file? Question mixed with argumentation. It's not productive for an examination. If the witness has been obstructing communication of documents, it's done by way of separate motion. How do you know that it was 1/10 of 1%? Let the witness answer. Can you provide us with that information? Let the witness answer. If the witness fails to provide you with the information that they've identified exists, then you go with a motion to sanction obstruction or failure to communicate required documents. You do not couple argumentation with the question of fact.
You haven't produced those tapes.
Every video from where?
From you.
Oh, no. From after you and other law firms lobbied to have us taken off the internet, which had the index of it on YouTube and other platforms, and like Roku. Oh, he's doing it right now. Get it off right now. He's coming after the kids right now.
So when you told your audience he was dressed up in SWAT gear, that's just something you made up, isn't it?
How does the lawyer expect Alex Jones to answer that question? Yes, it's just something I made up. Again, it's a question of opinion that is going to allow the witness to explain their sentiments. And they're rarely going to explain their sentiments in a way that's going to prejudice their position in the file. These are questions that allow the witness to give the answer the witness wants and not factual information that the plaintiff might need.
There's no man in SWAT gear in that video, is there? That's just something you made up.
Yeah, I made it up. I'm a liar. Is that what he expects Alex Jones to testify?
Nope, I didn't make it up.
I mean, and really, if we look at this at the end of the day, really, you're the victim, aren't you?
This is argumentation, this is pleading, it's not what you do during the examination. And you're not going to get the answer you want for obvious reasons.
No, but I've certainly learned a lot in the process.
You've learned how to not be a reckless journalist, right?
You've learned how to not be a reckless journalist. How does he think the witness is going to answer that? Is that a question of fact, or is that just arguing with a witness to make yourself feel better?
Do you think that there's a question that I should have asked you today in deposition that I didn't?
I genuinely don't understand what the lawyer is doing with this question. Is there something I should have asked you in the deposition that I didn't? To me, it's an absolute mistake. It allows Alex Jones to offer any beneficial information that he wanted to offer that he didn't get a chance to during the examination. I don't know what the rationale was. I don't know what the strategy was, and it really could have come back to backfire against the attorney. It didn't, but not ever a question I would have asked. It's basically like asking a witness, tell me something that you want to tell me that I didn't ask you to allow you to tell me.
That's a good question. I can't think of any.
And that is the analysis. I hope you got something useful out of it for the attorneys, for the non-attorneys. Maybe now you sort of can appreciate the process. Examinations are never fun for anybody, but oftentimes lawyers treat them as a place to argue and sort of plead as opposed to do what you're supposed to do, which is extract factual information from witnesses of fact for the purposes of later including in your proceedings for the purposes of making argumentation and pleading later on. Peace out.